everybody.
Okay. Hello, everyone. Good afternoon, good evening, wherever you might be joining us from. We are excited that you are joining us in this session. As an entrepreneur, a SHPE member, or wherever it is that you're joining us from, we are going to be covering Am I Covered? Legal Foundations to Protect My Business. A few things before we get started. Feel free to connect, and we actually have different ways that we're going to be sharing with you on how to connect, how to engage. But before it, please have your camera on if you can. It makes it much easier engaging when we see each other, especially when the speakers can actually see you, they can engage with you, they see your expressions. And then also other members, right? So it's always great to see you. So turn on your camera if you can. Uh, Also, as the session is going to be going, please mute your mic unless you are going to be speaking. And how you can actually have questions. We have captured a few of the questions that some of you have shared with us and some things that you wanted us to cover for this session, which is why this session is brought to all of you. But feel free if you still want to make sure that it gets addressed here. Make sure that you go to the Q&A to address it. This way it doesn't get lost with all the different conversations and engagement that's going to be going on at the chat. So go to the Q&A and ask your questions. There is going to be a dedicated time that each speaker is going to have so you can ask your questions and they can engage. And we're also going to be bringing opportunities after if there's anything that we haven't addressed. We're going to be doing a closing survey, so this is very helpful. Please make sure that you connect with us and you let us know, was this helpful? This is what you expected. How can we improve? How can we bring some of these sessions better so it actually addresses your needs? Now, this is an exciting session because it combines two very important things, right? How do we bring in an idea, but how are we going to be protected? So let's stay connected. Here's two QR codes that you can continue that conversation. You can continue engagements. You can continue to be involved. So please do the QR codes so you know what's coming up. If there's going to be follow-up sessions, if there's anything that we can further connect with you, these are going to be some of the places that we can connect. My name is Yvette. You can call me Ivy. I am a sales engineer, so I do have a engineering background, a computer engineering background. I do sales. I'm going to be the moderator for today. I get to have the excitement opportunity to moderate this session, which actually in my position is a lot of the questions is probably similar to the ones that you have. So I am excited about this session to learn and grow and have some foundation in what our professionals in the legal area are going to help us cover. With all of that, feel free to engage in the messages in the chat. Let us know where you're connecting from. Don't forget the Q&A is for questions only, and they're going to be a dedicated time. And at the end, we might want to grab everyone and take a picture together just so we can capture the moment. So let's get started. First, we're going to be introducing each one of our amazing presenters that is going to introduce ourselves. So first, Pamela, thank you for joining us, and thank you all for being here. Pamela uh, is going to be our first speaker, and please let us do a brief introduction.
Sure. Hello, everyone. Thank you, Ivy, for the introduction. My name is Pamela Rosario. I'm a New York licensed attorney in the area of business and intellectual property. And my practice focuses on entrepreneurship law, helping businesses protect their businesses, their intellectual property, and just kind of setting them up for solid legal foundations in order to be able to grow and scale their businesses.
Awesome. Thank you so much, Pamela, and thank you for dedicating this time so you can share a lot of your expertise with us and get us covered. Cassidy, may you please do a brief introduction?
Hi, everybody. I'm Cassidy Aranda. I'm an intellectual property attorney that is barred in Illinois. I have my background in electrical and computer engineering, so very familiar with everything engineering. That's actually how I got my start into doing IP law. So I do a lot of patent, copyright, trademark work, and very excited to be here today with the community and sharing everything we know about intellectual property.
Awesome. And also thank you for dedicating the time for us because it's a different area, but it's so well combined. And I am looking forward to what both of you ladies are going to be sharing. So Pamela is actually going to get us started.
Yeah.
And it's Pamela, thank you so much. So please kick us off. This is your expertise.
Thank you so much. Hello again, everyone. I am really happy to be here and excited to chat with you all today. As you can see, today I'll be going over legal foundations for new and existing businesses. I like to call or kind of divvy that up into the three legal pillars that every business needs in order to build or tighten within their business. So, just to give a quick lay of the land, if you see here, today we'll be talking about the first pillar, which is kind of business entity and financial logistics, contractual protections as pillar two, and then briefly touching on intellectual property protections, which I'll just briefly touch on because my lovely co-presenter Cassidy will be doing a much deeper dive after. Um, yes, thank you. Before we get into any of that, just some quick housekeeping. And I'm sure, again, I can speak for my co-presenter here, Cassidy, as well. We are attorneys, but we are not your attorneys. So, there's no attorney-client relationship being formed here, and everything that we share, gladly, of course, is for informational and educational purposes only. So, with that out of the way, we can get into why we're all here. So when I talk about these legal foundations, right, the point is, as I mentioned briefly, is so that your business foundation is solid and that you are set up before you get into those next phases to grow and scale. Because if your foundation is a little bit shaky, if it's not set correctly, if there are things that are missing, that's not going to be great for the future of your business. And so that's what these pillars are. That's what I envision. And that's what I tell my clients to kind of think about. Always have these pillars in your mind. That way, the setup allows you to not only foster that growth and expansion of your business, but do it in a way that makes you feel comfortable and safe and secure. So, in talking about the first pillar, pillar number one, we are talking business entity and financial logistics. So, your business entity, whether that is a limited liability company, a corporation, or a nonprofit, an entity is essentially what's created to create a liability shield between you, yourself, the person, your individual assets, your individual bank accounts, any property you own, and separate that from your business. The goal of that really is if something goes wrong in the business, and we hope that it doesn't, but if something goes wrong, if your business gets sued, you don't want your personal savings, your personal assets, any of those things to be affected, right? So we're essentially drawing a shield or a line between yourself and your business. And that's why business entities exist by and large. So that's the question from a legal perspective. The question I always get is which one should I set up? Should I set up an LLC? Should I set up a nonprofit? Should it be a corporation? While that does have some legal components, a lot of people are shocked to hear that it's actually a tax question, something that you should be talking through with an accountant, your tax professional, whomever that you go to for this type of tax advice. You always want to loop in your tax professional person when talking about your business entity setup and when you set it up. That's another question that's always asked. When do I set up the business entity? Do I start while I'm making money, before I make money in the business, when I'm still thinking about an idea? As attorneys, again, we're not really supposed to go into the tax realm. So that's something that I would speak to a tax professional on. But from a legal standpoint, the idea is separating these things. So I usually tell my clients, if you do find yourself paying for things for the business, making money from the business, that's probably a good point to speak to a tax professional and likely set up a business entity. The good thing is that this part of the process, there's a lower barrier to entry, meaning you can start an LLC, for example, online in most states for a couple $100, depending on the state, and sometimes automatically created or within a couple of days or weeks. So the protections that you get, that shield that I'm talking about, it's impactful, and then the effort is relatively small for what you're getting, that liability shield. What I will say though is that uh, whether you choose an LLC, a limited liability company, a corporation, or a nonprofit really depends on your specific business goals. So, usually the most common business entity for a small business is the limited liability company, the LLC, because like I said, it's the easiest to form, usually the quickest, and it has a little bit of less management throughout the life cycle of the business than, say, a corporation. But it is, you kind of have to take a holistic view at your situation, what kind of business you're in, what you're doing, what stage you're in, to really decide which entity makes sense when you form it. And another question I get asked a lot is where you form your entity, right? Uh, Another it depends answer. I would say there's a lot of factors that go into that. Where do you live? Where are you operating the business? Where your clients are? Um, but I do want to emphasize that please stay away from kind of the generic online social media advice that says, for example, the best state to set up your business entity is Delaware or Wyoming. These are painted as advantageous from a tax perspective. And that could be true, but it's not always true. And it really depends on your business goals. You might unknowingly set yourself up for things that you didn't intend. For example, most people don't know that Delaware has a franchise tax that LLCs have to pay every year. Whether you're making money in the business or not, that tax is due. And that can be costly for some small business owners. So, especially ones that have no connections to Delaware. So always seek that legal and tax advice in combination before making this choice on the business entity. And don't just go by what the internet likes to talk about that particular week. So next is your employer identification number or your EIN. We're still building this financial kind of pillar. Your EIN is essentially your business's social security number. So this is what you need in order to be able to get paid by your customers and clients through that business entity that you created that we just talked about. And so that EIN is attached to that business entity, and that's also what you need to open up a business bank account, which we'll talk about in a little bit. In order to get an EIN, it's actually completely free on the IRS website. And I can provide some links to some of the resources that I talk about today. There are services out there that will get the EIN for you, but honestly, it's a pretty simple process in the IRS website. So that's somewhere where you can save some money and DIY this process by getting your own EIN number, and it's automatic. Once you finish the application, the number is automatically generated for you. And just like in getting the EIN, there are other reputable companies that I recommend to clients to set up the business entity as well. I think in the past, people believed that you needed an attorney to set up the business entity. And while there are portions of that process that you might need some legal help, maybe in the operating agreement, which we'll talk about in a bit. You can have an attorney do this for you, but you don't have to. There are companies like LegalZoom or Zen Business where this is their everyday bread and butter. They're filing services, and so they do this day in and day out, and you can trust that they can help you form your LLC, get your EIN if you needed. And of course, that comes with an extra cost, but for the most part, I wouldn't recommend doing this completely blindly yourself on the various state websites. Just uh, grabbing onto a little bit of assistance from some of these companies, I think will be helpful. And then lastly, to close out this pillar, is your business bank account. So, like I said, what you need to open up the business bank account is your business entity paperwork, like articles of organization or your certificate of incorporation, your EIN number, and those are the materials that you take to the bank to open up a bank account. A lot of people usually ask, should I go for one of the big banks like Chase or, some other alternatives? With the bigger banks, with each option, I would say that there are benefits and disadvantages. With the bigger banks, they're a bit more tech forward, a bit more modern, so you get that advantage. But sometimes their monthly fees can be a little bit high, especially for small businesses, depending on how much money you're keeping in the account. So I do love to recommend finding a reputable, smaller bank or credit union. I love recommending these to small businesses because these organizations, they want your business. They want people to join the credit union. They want people to join the local community bank. And so there might be incentives, signing bonuses, for new business accounts. But most importantly, you get to really form a relationship with this bank, which will be beneficial later on because if you're ever looking for a small business loan or a business line of credit, this is an organization, financial organization with whom you started this relationship with. So if you can swing it, I would do some research on some local smaller community banks and credit unions. Just make sure, obviously, that they're FDIC insured and they have all of the bells and whistles that you need. One thing that sorry, we'll get to that in a bit, but really quick, just to close out this pillar, one thing that I like to stress also about the business bank account, and it goes back to the business entity and that separation from the business and yourself as an individual, is the whole point, or one of the points of the business bank account is to have that separation between your business finances and your personal finances. You don't want to mix them. Otherwise, that's called commingling of funds. So meaning mixing your business money with your personal money. And your accountant will tell you the same thing. What you want to ensure is that any money that you are spending on the business is coming out of that bank account, that business bank account, and any money that you are making from the business is going into that bank account. That way you have the clearest picture of your expenses, your costs, your revenue, the income that's coming into your business. And again, easiest way, best way, really only way to separate your personal finances from your business finances. And it also just creates a clean financial record for you and your tax professional or accountant. Okay, let's move on to the next pillar, which is contracts, one of my personal favorites, but sadly, the pillar that most people often skip, most businesses. The general rule, I think, is anything that involves the exchange of money or rights should be in writing. So if you think of contracts, they are the blueprint, to any kind of business relationship. If you are giving someone something from your business, if someone is giving something to you, providing a product or service to your business, you need to have that blueprint. You need to have that contract in place so that everyone understands what's supposed to be happening. And that includes, obviously, the roles and responsibilities of the parties. what is happening in this agreement? How much is being paid? When is the payment being made? How is it being made? What happens if someone wants to terminate the agreement? What happens if someone wants to get out? What happens if someone is not holding up their end of the bargain? What's included in the relationship, meaning the scope? And this is really why contracts are so key. And it's actually, like I said, one of the areas that I see so many small business owners skip, because we do a lot of handshake deals, right? In the beginning, especially when we're starting businesses, we think, oh, I don't want to ruffle any feathers, or I don't want, this person to sign an NDA or a contract because I don't want to kill the deal. Or what I see very often is I'm working with my friend or my family member, so, I trust them. A contract is not necessary. I completely disagree. And actually, I think, in those instances when you have friends or family members, you need a contract even more because there's really no better way to protect that business relationship, but also that personal relationship, than to have an agreement in place, than to have a contract, right? Because if something goes wrong, personal relationships and personal issues really don't have to come into play. Everyone can just look back to the contract. So there's no question to what was supposed to happen or what someone feels or anything like that. No one can say, you didn't tell me this. I didn't know this was going to happen. It's in the agreement. Both sides agreed prior to signing, the project or collaboration or business. And so it really acts as kind of insurance for the transaction, the collaboration, the partnership, to have that agreement in writing and really protects relationships as best it can, moving forward. So again, when things go wrong, back to the agreement.
Hey, Pamela, I think we're losing your audio.
I don't know to transfer in your business or moving forward and grow your business.
You.
Your internal are in team. And don't necessarily hire. Does someone have a question?
I was just saying we were losing your audio, so we were really not able to hear those pieces that you just said, and it looks like your camera might be frozen.
Yeah, I wasn't sure if it was on my side, but thank you for jumping in.
Okay. Okay. Well, while Pamela gets settled, maybe we can, or maybe Pamela's back. Is it working for you now, Pamela?
Yeah.
No,
Yeah.
we
Keep it
can't
with
hear
us.
you.
Oh,
Sorry,
you're
I'm not sure
back?
what happened.
Oh no, you're still breaking up.
Yep, it's still choppy. So why don't we give it a minute and let Cassidy speak for a few minutes, maybe while your internet catches up.
Okay. No
Okay.
worries. Wow, that was great information. Thank you so much, Pamela. I'm over here taking notes. I hope you guys are too.
Yes. Now, Cassidy, do you want me to jump to your slides?
Yes,
Can
but before we
you
do that, let's try one more time with Pamela and then we'll
yeah.
go from there. See,
Can
Pamela.
you all hear me now? Is that better?
It is much better,
Okay,
yes.
sorry about that. Just so you all know, I am phoning in from Spain, so the internet's not that great, as great here as it is in the United States. So sorry about that.
No,
Someone
you're good. You sound
someone
good.
did recommend turning off my video. I think it's fine now, but if it gets choppy again, I'll do that. Please let me know.
Okay.
Okay, so I was saying, talking about internal contracts versus external contracts. As the business owner, I think that's kind of the best way to look at these agreements that you'll need for the business. And like I said, not just for employees, internally, if you hire contractors, freelancers, someone to manage your social media, someone to act as your virtual assistant, those are your internal facing contracts. And for the same reasons we've mentioned, You want to make sure that you and this person that you are hiring for your team understand what you're supposed to be doing, how much you are paying them, what service they're providing for your company, how much they're being paid, and sometimes most importantly, what happens if they don't perform? What is the out? What kind of remedy or resolution do you have in that agreement? And then you have your external contracts. This could be with outside vendors that aren't necessarily ongoing freelancers for your company or exclusively, but people that you do have ongoing relationships with. So maybe someone that you hire to build your website, design your logo, or for example, if you create a product and you need a manufacturer or someone supplying materials, those are those external relationships. And you need to have things in place like a manufacturing agreement, a supplier agreement. Again, same purpose, making sure everyone knows their obligations and you have remedies or solutions when something doesn't go as planned. Now, this is particularly important when you're hiring someone to create an asset for you. And we'll talk more about this in the IP section, and I'm sure Cassidy will as well. But for example, if you hire someone to create, excuse me, a business logo for your business, you need to make sure that there's an agreement that assigns or transfers that intellectual property asset, those IP rights, to that logo to your business. Otherwise, for example, copyright law says that whoever creates the work is the owner of that work if there's not an agreement in place. And so that agreement, that contract is so critical in that situation because by default, by law, generally, a logo designer owns every logo, owns the copyright to every logo that they design, unless there's an agreement that says otherwise. So really key. Even in collaborations, if you've set up to maybe barter with another business or you're hosting an event together, even if there's no money being exchanged, you still need something in writing. I always say if it's not in writing, it's kind of just a conversation and it's not an agreement. So contracts, really, really important, and they're so overlooked. Also, I think that people think about contracts only after something has gone wrong. I have a lot of conversations with clients that come to me after they've been in some kind of business relationship and the other party didn't pay or they didn't perform or they want to back out. And my first question is always, what does the contract say? Because that's what we look to. That's what we have to work with. And there is no agreement. There's no contract. So at that point, you're really left with just trying to negotiate between yourselves, which doesn't always go well, or escalating and bringing attorneys to negotiate, which costs money. And in the worst case scenario, you're talking about filing lawsuits and going to court and letting judges and juries decide. You want to avoid all of that, right? Not just because obviously it's a headache, but financially, you have to invest time and money into that. And I understand hiring an attorney to draft or review an agreement, it may feel expensive upfront, and it can be, but it really pales in comparison to what you'll spend trying to fix a situation that wasn't properly documented. So I'll get off my soapbox on contracts, but I just think that they're so overlooked as small businesses, and implementing them correctly can avoid so many financial headaches down the line. So when in doubt, always get it in writing. Okay. And the last pillar is honestly one that we could spend an entire hour or two just talking about: intellectual property. Excuse me. Like I mentioned, Cassidy is going to do a much deeper dive on this, but I did want to introduce really quickly the three main types of intellectual property, and also explain them in the context of being a business owner and running your business. One of the key things to remember about intellectual property or IP is that it's everywhere. It's not just for really large corporations. If you are building something, creating something, branding something, you have IP and it needs to be protected. So not only do you want to protect your own IP, your business's own IP from being copied or used by others, but you also want to make sure that your business is not inadvertently using someone else's intellectual property. So we can quickly start with patents. I will be extra brief here because patents are a very specialized area of intellectual property. For example, whereas my practice focuses on trademarks and copyrights, to become a patent attorney, like Amazing Cassidy, you have to take a separate bar exam. So high level, very specialized area. But patents protect inventions generally, right? So things like processes, machinery, designs, even certain types of software. For example, if you have a unique manufacturing technique or a special kind of technology, those are all things that may be patentable. Even the design or shape of a product can sometimes be protected by a patent. Moving on to trademarks. Trademarks are about branding and your brand identity and marketing, really. These are the things that identify your business in the marketplace. So if you think about the golden arches of McDonald's, the Nike swoosh or check mark, the Nike name, their slogan, just do it. When I say all of these things, you're immediately thinking of these companies, right? And so these are all trademarks. They help consumers connect a brand with a specific company. When someone sees your business name, your business logo, your business slogan, they should immediately associate that with your business. At least that's the goal for trademarks and branding. And so that's what trademark protection is designed to safeguard. When you put the time, effort, and money into building your business's brand, you don't want other companies to be able to profit or benefit from that hard-earned brand identity, those trademarks. And so that's why you want to protect those assets. And then lastly, we have copyrights. I usually kind of explain copyrights as copyrights equal content. So it's not about your public-facing brand, it's about what your business or you create. So that includes things like books, music, blog articles, images, videos, and other creative works. In relation to your business, however, you want to look into IP in two ways. First, of course, protecting your business's intellectual property, like we just talked about. That includes your brand, your content, and anything unique that your business is creating or has created. But second, and just as important, is making sure that you and your business are not using someone else's intellectual property without permission or inadvertently. You want to make sure to clear your trademarks so that you're not building all of that brand recognition and then have someone knocking on your door saying that you're using their brand name or you're using their logo or their slogan. You don't want to just be pulling images off of Google or Pinterest or Instagram and then using it on your business website. You know, that's someone's hopefully copyrighted image, but someone has the ownership rights to those images or those videos. And again, it just opens you up to that individual, that business who owns the copyright coming to you and, you know, with a cease and desist saying that you infringed on their copyright. In most cases, almost all cases, to use someone else's intellectual property, you need permission. And that typically means some kind of license agreement. You need to properly attribute the asset to them or give them credit. And sometimes that does come with paying some kind of fee for the use of that intellectual property. So really, really important to understand as a business owner, not just how to protect your own IP, but also how to avoid putting yourself and your business at risk for these kind of infringement issues. This is especially important nowadays in the age of social media and just the internet, where content is so easy to copy and download and reuse. You have to be especially diligent about that. Because when you're using something for your business specifically, a lot of people say, well, oh, you know, on my personal Instagram, I've used someone else's image and that's not an issue. The issue is when you're using it, the image or the asset or whatever IP for your business, you're using it commercially, right? You're using it to promote your business, to fill your website with images or whatever the case is. And that puts you much closer to this infringement territory if you don't have the proper rights, permission, and all the things that we just talked about. So these are the three pillars that I really like to emphasize. And I think as you're building a business, whether you've already started one or you are thinking about building a new one, if you always have these pillars going in your mind, I think that's really, really helpful. In not just viewing your business as something that's attainable, whether it's a side business or a full-time one, but also something that doesn't seem so scary, you know? I like to say that starting a business now, it's not easy. I won't say that it's easy. There are risks involved. But it's so much simpler, I think, than most people think, and less scary once you understand what the steps are, right? I need a business entity. I need to have an EIN and I need to have a business bank account. Okay. I need to have certain kinds of contracts depending on what business I am in, who I serve, who I help, who my clients are, and what I want my team to look like. And then I need to set up some kind of IP foundation, whether it's my trademarks, the images on my website, blog articles that I am writing. With all of the resources available for small businesses now, I think the path to that entrepreneurship is much clearer than it used to be. So as long as you set your foundation right with all of the pillars that we just discussed, having that business entity, those logistics in place, having those contractual protections, knowing what IP you have, protecting it, and making sure you're not using anyone else's IP without permission. Setting that foundation right not only will obviously protect you, but I think it gives you a level of confidence as a business owner to move forward in that entrepreneurial journey. And then lastly, I just want to kind of emphasize that none of this is about doing everything perfectly exactly on day one, right? It's about putting the pieces into place as you grow, so that you're not trying to fix problems later when they might be more expensive or a little bit harder to do. This all doesn't have to happen at day one, before you start. But if you start putting the pieces in motion, I think that's the best path forward.
Thank you so much, Pamela. That's the saying goes, right? You can recognize a master because they make it look so simple and they demystify the whole area, right? I think this is pretty clear. Thank you, because this is a really good, here's how to get started step by step and things to
Yes.
identify. So this is a good base and foundation to actually get Cassidy to get us deep dive. And remember, everyone, that we are gonna make time to answer your questions and address your questions. So let's get Cassidy to share some of the great content and expertise she has, and then we'll open to questions. Sounds good?
Yes.
I hope you're all learning. Thank you, Cassidy. Thank you, Pamela.
Okay. Hi, everyone. Thank you so much for the great introduction for intellectual property. That was fabulous. Okay, so let's start with patents. So, patents. What is a patent? A patent basically is the right to exclude others from making, using, offering for sale, or selling the invention, whatever it is, in the United States. So, actually, this right to have a patent, this was written in Article 1, Section 8 of our Constitution. So, in exchange for telling the public every single little detail about your invention and in different claims throughout your specification, throughout drawings, which I'll show in the next couple slides, you get to have a monopoly for the next 20 years, starting from the day that you file your patent application. For the next 20 years, it's your monopoly. So anybody else who comes up with your invention, you can go ahead and send them cease and desist letters or just tell them to stop. Do you want to get a license from me if you're going to use my invention? So that's the advantage of having a patent. And let's go to the next slide. Okay, so here's the general patent timeline. So first, you're going to determine if your invention is patentable. Typically, you can go to different attorneys out there. They can run a patent search for you. I do these all the time as an attorney. And so you kind of get a general landscape of what the patent world looks like. So if you are familiar too with like certain processes, certain ways of doing things, but you're so intuitive and you're like, there's definitely a better way to do this. You can get a patent on that, even if it's already an idea that's already been created. So that's the first step, brainstorming, testing. As an engineer myself, I'm very familiar with this process. It's about failing again, and then finally, on maybe the 12th failure, you get an amazing result that you're like, oh, this is brand new and super inventive, and let's get this out there in the world and help people in whatever way we can. So after you come up with that great idea, you run it by with a patent inventor, or sorry, with a patent attorney, and they're like, yep, it looks like this is a brand new invention. The next step is preparing the patent application. And so you need a specification, an oath saying like, yep, this is my invention, an application data sheet, drawings, and also the applicable fees. This is definitely one of the more costly parts of the patent application because you are asking an expert to go ahead and draft a patent application. I don't know if any of you guys have read through a patent application. I read through a patent application for the first time as a 1L in law school, and I was like, what is this language? This is a little insane. So it's definitely an art to create a patent application, and that's why you definitely want to hire an attorney to help you through that process. The next step is filing the application through the USPTO website, and these filing fees typically range from anywhere $400 to $2,000, depending on if you're a small entity, a micro entity, or just a regular entity. And you qualify to be a small entity if you have less than 500 employees. If you have more than 500 employees, you do have a larger fee. So check that out on your end as well. The next step is the examination process. This is also I would say a more expensive part of it. In total, patents can cost anywhere from $5,000 to upwards of like $50,000, depending on the complexity of your patent, depending on how much of a scope you would really like to get out there. And also, too, this examination process. This is when office actions are sent between the USPTO and the patent agent or attorney. So you've already come up with your invention, you send it to the USPTO, and the USPTO is like, this is a great idea, but I've already seen this idea before. And they'll send you like 6 pieces of prior art that already have your invention or like parts of your invention in it. And they're like, I'm not convinced that you are able to overcome like this prior art. I really don't think that your idea is super new. So patent attorneys, and patent agents, which if you would like to be a patent attorney or agent, side note, anyone who has a STEM degree, generally, I think there's some nuances with a STEM degree. You can qualify to take the patent bar exam without going to law school, and you can become a patent agent. So just a little side note if you're an engineer and interested in going that route as well. Okay, back to it. So office actions. So yes, then patent agents discuss and argue why the application can stand up on its own. We usually look at the claim sets. We try to rework the claims to see, okay, what are ways that we can strengthen what we're trying to say so that we do prove to the USPTO that we are a brand new invention and nobody else has ever thought of this before. That's why the specification is so important, because the specification is basically like the broadest scope of anything and everything that you could like think of in your invention. If there's different iterations that you want to come out, so like you have this base idea, but like like it could go XYZ way, you want to include all those XYZ pieces of information in your specification so that you can maybe even have continuation applications that branch off into different ideas as well. So that's what the examination process looks like. And then after that, the next step is, oh, congratulations, your patent has issued by the USPTO office. There's also maintenance fees that are due at 3.5 years, 7.5 years, and 11.5 years after the issue date. So make sure that you keep up to date with those as well. Okay, Next slide. Okay, so there's three different types of patents. There is a design patent. So design patent typically focuses on what an item looks like. So take a pen. This is my favorite pen that I write with. So you have a utility patent, which could be, so here's a method of writing. I dip my pen in my ink and then I write with my pen. That could be a utility patent. But a design patent is, okay, what is this pen that I make look like? I have like this cool little feather. I have this little tip. All of these things would be on a design patent. So a design patent protects how your item looks, how your invention looks, and a utility patent protects how it works. Or just, yes, your different methods, your different processes. And I know it's really hard to see here, but if you see everything that I circled in pink right here, that's claim language. And I don't know if you guys can read it, but it's kind of insane. Let me see. Yeah, thank you so much. If we could just zoom in for a little bit to like claim one. Okay. An apparatus for surgically removing um, from the posterior chamber, like I don't even know what this says. This is this is in the bioengineering space that I am definitely not familiar with, but you can see how complex this language is. You have words like means for passing an end of the line. These are all this is the artistic approach of the patent attorney. So would definitely recommend hiring a patent attorney to help you get the broadest scope of protection that you can with your invention. And also you can patent plants. So avocados, for example. We can go to the next slide. Okay, so now we're on to the trademark part. Also, before I leave the patent area, I want to let you guys know that right now it takes approximately 22 months. So if you were to file it today, your patent application, it takes approximately 22 months to receive your first office action. So just wanted to let you guys know what that timeline looks like. It typically takes anywhere from like 2, 3, maybe even 5 years for prosecution. So keep that in mind. And remember too, the moment that you file your application, that is when your clock starts ticking for your 20 years. And also too, if you, let's say like you put something out on Etsy, right? You put out your invention and you put it out on January 1st, 2026, you have 1 year. You have until January 1st, 2027 to file your application without it being prior art. So if you guys have something that you already put out there, be cognizant that you have only 1 year from the day that you first put it out into the public to go ahead and get that patent. Okay, thank you. So on to trademarks. So here we have trademarks. I just want to tell you guys the difference between R and TM. R means that it is a registered mark on the United States Patent and Trademark Office. At what point can you say patent pending? You can say patent pending as soon as your application is filed. Your application must be on file, and then you can go ahead and say patent pending. Okay, trademark. Okay, R. So once you have filed your trademark and you've also been approved, you received notice of allowance, you paid your issue fee, you paid whatever fees need to be secured, and it's on the registry, you can go ahead and start using your R. So here, for example, I have Dr. Martens with an R circle. That's because it is officially trademarked. And here is an example of what the trademark sees. So here we have the US serial number, you have your application filing date, your registration date, your publication date, and all of these are really important to know because all these different dates will be used like just in case some other person comes along and is like, oh, no, I had the trademark first, or I created this idea first. Well, I have the first use date here on my application on my registration for Doc Martens. Okay, and then also TM. So if you are a common law mark, so I'm here in Illinois, if somebody's using their mark actively in Illinois, they can go ahead and use a TM. You can also use TMs while you're waiting for your mark to be registered. Right now, it takes about 5 months to get a first office action on a trademark. So that's approximately the timeline that you would have to wait for now. But yes, a trademark is any word, phrase, symbol, design, combination of these things that identifies your goods. And it's really important that you have a trademark because actually, we can go to the next slide. I have that point later on. Okay, I wanted to share this resource with you. This is Tess. So I highly recommend going to this website and just taking like a first look. If you have an idea of you're like, oh, this is a great brand name, and I like absolutely nobody else has ever created that. I think a great first place for you to start is with a trademark search. Of course, you can hire an attorney to do this if you would like a really deep dive to make sure you're not infringing on anybody's rights. But if you're just starting out and you just like want to have a general lay of the land, I highly recommend going here, just typing in your name. Let's say your business name is featherinc.com. So you just type into the word mark feather ink, feather, if that's what you want your brand to be. See if there's anybody else who already has a trademark, but this is a really good first place for you guys to check out what is available and what's not available, so you can avoid a lawsuit. Next slide. Okay, trademark basics. So you have a basic filing fee for your trademark, so it's about $350 per class, and there's different classes of goods and services. So if you are a good, like let's say Summer Fridays or Taco Bell or Lego, Taco Bell sells tacos, right? Lego sells different Lego toys. All of these are goods, so each individual good that they want. So for example, Summer Fridays would say, I would like lip liner as one of my classes that I file for. So then it would be $350 for that one class of lip liners. But let's say that it also would like to sell sunblock or blush. That might be under a different class. So therefore, you have to calculate all the different classes that you want to use. What is the scope of your brand going to be? That's what you're going to go ahead and file for. I also highly recommend filing or hiring an attorney for this part. And then also too, why are trademarks important? When you go to Taco Bell, you're expecting a potato taco, right? You don't want some random potato taco that the guy down the street from you made. You don't know what's in his product. Like you see a Taco Bell logo and you expect a Taco Bell quality taco. So that's why it's so important to like trademark items to like let the people know that like this is a reputable place. This is our brand and nobody else is going to imitate these potato tacos from Taco Bell. It's safe to eat. It's what FDA approved, if they do FDA approved, whatever their process is, but you know that like this is like the real thing. And so it's huge for consumer safety to have your trademarks. And here you have examples of, see on the Lego, you have like a little R circling it. And I also put this Rivian logo here because I wanted to show you that not only can you trademark words, you can also trademark little designs. So if you look at the left hand side of Rivian, it has like a little diamond shape. So that's like, so that plus the words are different things that you can do. So it's not just limited to words, but I highly recommend starting with words in the beginning because your brand might evolve, your different logos that you use might evolve as you go. So wait at least like 1 or 2 years of like solid use of a logo before moving forward with trademarking like a little logo like that diamond shape, but definitely start from the beginning with the words, just like Rivian did on the right. So every 5 years after you get the trademark, you need to continue to renew it. The declaration of use basically says like, yes, I'm continuing to sell tacos at Taco Bell. So here's my declaration of use. And then every 10 years, you have to renew the trademarks. So the advantage of trademarks is that they could last forever. There's two different types of applications, but I don't think we have time to get to that. So let's get to the next page. Okay, and then copyrights. So, copyrights are artistic, literary, or intellectual created works. If you see a C with a circle, that's a copyright. Here's an example to the right of a registered copyright. Angela Y. Davis. I don't know if any of you guys have read her, but her books are incredible. Here's her registration number for a woman, race, and class. Um, if status is dead or abandoned is available again. Yes, you can renew your trademark. There is a cost with that, but it is possible to renew a dead trademark application. Okay, we can go to the next page. Okay, so basic filing fees for copyrights, $45 to $125, depending on the process that you decide to go with. But right now, it takes about 3 months to 11 months, depending on which one you file, to go ahead and get your copyright. But if you have a movie, if you have recipes, if you have a book, if you have music, all of this is covered under copyright. And I highly recommend that you file it with the Copyright Office, because if you don't file it with the Copyright Office, then you can't you can't send it to in a cease and desist and like tell people like, oh, this is my copyright. Well, is it registered? Like if you ever come into a case where you have to file a lawsuit, you need to have a registered copyright. But generally it lasts for your entire lifetime plus another 70 years. Yes, so and then also too with the various prices, I know I think there's like an $85 fee. So like say you have 10 recipes instead of one that you want to file, you can actually like get like 10 recipes all filed together under one copyright for a certain price. So yeah, I think that's my last slide. I know we're running a little, yep, let's go ahead and go to the question and answer section.
Pamela and Kathy, thank you so much, Cassidy, for speeding right by, getting us wrapped up right on time. Team, if Cassidy and Pamela, are you willing to stick around? We would love to address some questions. Many of the questions that have been asked here have been addressed. As you can see, one is the best legal structure. But if there's anything that hasn't been covered or you would like to address it, it's an urgent kind of question, please raise your hand and we have the experts here to help.
Yeah, I just want to add for that question. As you saw, I said it depends a lot. So there's no one size fits all answer to that question. It depends on your business goals. For example, if your goal is, you are mission driven, you want to fundraise with grants and donations, then a nonprofit would make sense. If, your goal is profit and maybe a little bit more flexibility, then an LLC. But the biggest takeaway I would say is that it's part legal, mostly tax driven. So you want to make that decision with an attorney and a tax professional. There's no one size fits all.
Thank you. All right, team, any questions? I mean, anyone that's already in the process that has some experience in this process, any top of mind things that are coming up? Feel free to raise your hand and
Okay, I see a patent bar question. Don't self-study. Buy the course. I think I got patent ILP. I don't remember, but also get a law firm to pay for it. That's an option. I did not have $4,000 as a law student. So I asked my law firm, hey, would you be willing to pay 4K for my course? And they said yes, or your engineering firm or whoever. But yes, get a business to pay for it. Yes. Also, I failed 3 times, so maybe twice, and then I passed on the third time. I thought it was harder than the bar.
I bet it is, yeah. I can go over the question on whether a side business affects your current employer. It can. I would really read your employment agreement or employee handbook or employer policies. Some employers say that you can't have any outside employment outside of that company. Some say that you can't have competitive employment, and so, anything within the same industry. So, be sure to look at that, what the internal policies are. And then also really, really important, be careful not to use company equipment to build your business. I know that sounds kind of like obvious, but use separate computers, and just don't use any of their equipment to build your business or to create anything in general. It just gets complicated when it comes to IP sometimes. I don't want to get too much into it, but the safest approach would be to review your employment materials for your company. Make sure that your business is separate, that you're not using your employer time, resources, or any confidential information, of course.
Thank you. So another question is, how does it apply to software? Edwin, if you want to give us a little bit more background, I'm assuming that this is software that has been created. You want to protect it.
Yeah, exactly. So I have a software as a service. Um, and so I'm just curious, like, how's that impact it? Like, and my question might be a little generic, and I just don't know enough about it to ask the right questions, right? But the idea here is having like a software as a service where I could basically license out the software to my clients and then have them pay like a subscription fee to use my software. If there's anything I should be aware of in that sense.
I think, and I'll let Cassidy, expand on that, but I think software code can be copyrighted. So yeah, you would want to, copyright the code to the extent that you're able, and then definitely have some kind of like SaaS agreement, software as a service agreement with, the clients that you are working with, obviously talking about IP rights, and then of course all of the regular contract terms. How much are they paying you? What are you actually giving them access to? What you're not giving them access to or rights to, when it comes to the software that you've created. But in general, yeah, I think you would protect the code, and then also make sure you have those protections in place when you are releasing it to the public.
I haven't copied or I haven't patented any software in my experience. I'm sure maybe some of them exist, but from what I have seen is the process of how your software works, like what does your software do, that is eligible for patent protection. Does that answer your question, or do you have any other more specific questions about that? That answers it. Okay, but definitely get it copyrighted, I would recommend. I see a question about AI development. I'm guessing you're asking like if you like use AI to like build your business.
Well, and they're talking about AI images as well. I think
AI
both
images. So
images and creating basic concepts kind of stuff.
definitely, I mean, like I know AI is definitely helpful. I will say there is a lot of case law that says that if AI made it, it's not does not belong to you. You're not the inventor. You're not the person who owns it. So to avoid that, I would say like for your big overview ideas, like make sure that all comes from you and not comes from AI. AI, I'm sure is a tool that can help you, but for the big things that you would like to own and have ownership over, do not use AI for those.
We also have Jeremy. He raised his hand on the image. Are you around? Do you have a question?
I think that was his question.
Yes.
Oh yeah, okay, go Jared.
Yeah. Well, thank you guys. This is a really great information here for us. And Cassidy is somebody I've listened to my entire life. She's my sister, so thank you guys for having her on. She's awesome. But yeah, no, I think just to clarify, so like AI, what I'm doing right now and developing is I have an AI that will help me automate calls. So I have my own sales scripts. So I have for local businesses, like any kind of objections that customers would have, and I have a sales script that I go through in order to get them eventually to either place an order on a specific item or get them to sign up for a time to meet one on one with us. So it's just a little specific. I'm just wondering, like, how if I create my own AI sales agents that automates calls, but I'm using my own um, um, checklist to go through. I'm using my own sales script. How does that like? How do I make sure that I'm using my own sales AI or excuse me, my own script, but I'm not like I'm using the AI as a avenue of um, uh, talking to the customers and making sure that I don't miss calls. Like I was just wondering if I can get like any kind of like information about how do I protect my own AI sales or my own sales script.
Are you saying that you have created the script yourself without the use of AI, and then you're using the script to maybe train the agents or the tool that you're using?
Yes, yeah, it does train the tool, and yeah.
Yeah, if it's something like Cassidy said that you created 100%, maybe that script, that's something that you can copyright. The only caveat I would say is copyright protection only extends to the exact asset that you uploaded to the Copyright Office, right? So in that example, you upload this script to the Copyright Office and you get your registration certificate. If you materially, substantially change that script in any way, I don't want to say you lose the copyright protection, but you kind of have to keep registering any iterations of that script. But let's say you just have one script that you're using or a few, you can have copyright protection over that script. But I think I'd have to know a little bit more about how you're kind of integrating that into whatever tools that you're using. But yes, if it's a creation, an asset or something that you created 100%, you can always protect that. It's just something that you are taking from an AI output, that the law is still, pretty much saying, AIs aren't human, and so it's not a human invention, and so it can't be protected by the traditional, intellectual property protection methods. Does that make sense?
Yeah, no, that's pretty clear. Yeah, that was a little long question, but yeah, I appreciate it. Yeah, it's clear. Thank you.
And I'm so glad. Yeah, that was great. And then also too, the process that you do, like the process that you use to train AIs, if that's unique and has never been done before, that's something that can be potentially patent eligible too. Any other questions or anything that I missed?
I have a quick question. I don't know if you guys have time for it.
Yes, we'll
So,
take yours and maybe one more and wrap it up.
thank you. So it's about like logo generation creation, right? So we made this logo basically on Canva. Like it was originally much wider and like they have a template and stuff. And then we went in and like heavily changed the colors and the shape and everything, like just kind of edited it in Photoshop basically. And the frog itself is still like from Canva, but the kind of basically the rest of it is like we've edited it. And our understanding through like reading through Canva's usage is that we can use the logo, but we can't copyright. We can use like their images and stuff, but we can't copyright or trademark. I forget exactly which one it is. Um, that specifically. So I don't know if you guys have any more like information about like, okay, yeah, we're using images from Canva, which they allow us to use, but then we went and edited it. How does that like fit into like if it's copyrightable or I forget, is it copyright or
It's probably
trademark?
if you're using it as a logo, probably trademark.
Trademark. Okay, yeah, that's the one I meant. Yeah. Does that make sense? Does my question make sense there?
Did you use Canva Pro or just
I forget. I think
We
I
don't do
have
that
Pro.
process at SHIP, and my understanding from our attorneys is that if we used Canva and we created it entirely without using any of their imagery or whatever, we were just designing within it and using the colors and whatever, then we could. But if we use any part that is an image or any kind of piece that is theirs, then you cannot. But that's my understanding of what we've gone through at SHIP, like our entrepreneurship logo right now, and some of those things. So I don't know
I
if that
think,
helps.
yeah, in general, I would say definitely agree, Susan. The more original you can make the logo, meaning, in Canva, you can draw a frog, like an actual frog, and create it with your own assets, obviously within their platform. I think that's more trademarkable. That's not a word, but it is today. Than, using a lot of their already made assets because their terms of use or online terms specifically say that you can't use that as trademarks. There is some conversation about how much you change their assets, right? Whether you're using Canva Pro or not, if you change the colors a lot, if you cut the image in half, I don't know. I always, err on the side of caution, and I would move towards, creating the most original logos, pieces that you can. You also don't want to, come into a space where there could potentially be another company that has an asset that's so similar to yours because they also use Canva, that you head into confusion in the marketplace, or even, worst case scenario, some kind of infringement situation. So yeah, as original as you can make it, I would say.
That makes sense. Yeah. We have been looking into updating it, like
Yeah.
paying an artist to make it. But yeah, we've been using this one for about a year now.
All right. Any other last final question? If not, let's get in camera.
I
Susan, can you
I
help
have
us with?
I have a question.
Oh, who's that?
Um, just by the way, thank you very much, Cassidy's aunt. So great presentation. I love the presentation. Very informative. So I have a question. I'm creating a business, and I just want to know for the contracts. How do we define the scope of services to avoid misunderstanding with contracts for services of clients? So what I'm trying to do is just provide services for people with disabilities, and we're trying to build different abilities. So we want to have contracts for those clients that we're going to be serving. So I don't want them to eh, just the fact that the presentation involved like when you do it for families and things like that. So we just want to know what to do in how to concrete a very specific contract for those situations.
Yeah, I would say, this piece is actually, easier than you might think. It's really up to you, right? Like start thinking about your the client journey, the things that you want to provide as a business, write those out in plain English. Like we want to provide XYZ. We want to make sure that this happens. We want to make sure, literally the things that you are providing within the scope of how much you want to get paid, right? Maybe you have tiers, maybe there's a bucket, a package that you have that includes all of the bells and whistles, and it costs this one thing, and that scope includes some, a set of deliverables. Maybe you have smaller tiers, and so you start taking out deliverables. It's really all about what you want to include within that scope and what you don't want to include. Write it out in plain English. And then if you're working with an attorney or someone, they can help you make it a little bit legal. But honestly, if it's in plain English and it's in your contract and you understand it and your clients understand it, I think that's best case scenario. But it's really whatever it is that you want to include in the scope, in relation to the payment that you want the agreement to list. So I wouldn't say there's any magic language. You as the business owner own that process. And if you say you want certain things in the scope for this payment that you're asking, then it goes in. Now,
Okay.
when you have clients that go outside of the scope, that's something that's called scope creep. And that's why you want to make sure that
Ooh.
the language that goes into that scope is very clear so that it's not ambiguous or vague. And so your clients can say, well, it kind of sounded like that was included in the scope. That wasn't really clear that that wasn't included. So you just want to be as specific and clear as possible as to what is included and what's not included. And what is included is entirely up to you.
Perfect. Okay. Thank you very much.
You're welcome.
Great. So remember, everyone, Again, a big applause to Pamela and Cassidy. Thank you so much for educating us, bringing us awareness, getting up to date on some of the how do we stay protected and covered, right? And to our SHEP team, Susan and everyone else in the team, thank you for bringing these ongoing sessions to all of us. It's a lot of hard work. And to everyone who attended, thank you for participating, contributing, and being part of this community. Remember, these are going to be sent and shared, the recordings. And thank you all for the participation. Let's keep the engagement going. And we're hoping to hear more about all those patents and ideas that you are protecting. So if you are in the process,